Good morning. The conference committee between Senate Judiciary and House Corrections and Juvenile Justice will come to order. We have quite a few bills in conference, so we will be taking a look at those. And I would think that the first one we want to take a look at would be
somebody needs
is if we could have a bill brief on Senate Bill 366 and Senate Bill 408. We have a couple of indexes that have been shared with committee, and are they online as well? Not online, but if you want to have them emailed, please check in with the revisers for the committee, Ms. Natalie Scott and Mr. Jason Thompson. So with that, then, if we could have just kind of an overview of the conference committee index would be a good place to start. The bills. Thank you.
All right. Thank you, Madam Chair. Good morning, committee. Jason Thompson, Revisor's Office. So you have two Senate bills, Senate Bill 366 and Senate Bill 408. In Senate Bill 366, that is the specifying the crime of burglary includes, without authority, entering into or remaining within any locked or secured portion of any dwelling, building, or other structure with intent to commit another crime therein. You'll remember that the bill amends KSA 21-5807. That's the crime of burglary, and it does include that new requirement, or that new element of committing the crime by entering a secured portion of the dwelling or structure, rather than just the dwelling or structure itself. And then the House Committee amended the bill. Natalie, you want to chime in?
Thank you, Madam Chair. On this one, the House amendments were simply to change the effective date from the statute book, which would be July 1, to the Kansas Register.
Okay, and then on Senate Bill 408, that's the bill increasing the criminal penalties for multiple thefts of mail. You will recall that amends KSA 21-5801. That's the crime of theft, and it creates a special rule, essentially, that theft of mail worth less than $1,500 from 3 separate locations within 72 hours is a severity level 9 non-person felony. And mail is defined originally as a letter, postal card, package, or bag sent through the United States Postal Service or other delivery service, or any other article or thing contained therein, or a sealed article or thing addressed to a person. And then the House made some changes.
Madam Chair, the House changes on this bill were just to the definition of mail. The House Committee on Corrections removed "or a sealed article or thing addressed to a person" from that definition of mail.
Thank you. And then we have a couple of House bills as well.
Madam Chair, the first House bill that you have in conference is House Bill 2361. That would require the Supreme Court to adopt rules for the establishment and operation of specialty court programs. It also creates the Specialty Court Funding Advisory Committee and the Specialty Court Resource Fund. Section 2 of that bill would add ordering a defendant to participate in one of those specialty court programs to the list of sentencing alternatives in KSA 216604. And then Section 3 amends KSA 216614, that's the expungement statute, to allow a person to petition for expungement for an offense if they were ordered to participate in one of those specialty court programs and they successfully completed that program. They would also be required to not have any pending felony proceedings against them. And then the Senate made.
The Senate in committee did a substitute bill, and that was at the request of our office. There are no substantive differences between the two positions. 2 of the statutes that were just mentioned were amended in 2021, and because you all know we have to amend the current version of the law in order to meet our constitutional requirements, we had to put in the current version of the statute and make the same changes to the current version of the statute. So that basically led to a substitute bill to make that nice and clean.
And then the second House bill you have in conference is House Bill 2607. I would note this one's not quite totally in conference yet because we're still awaiting a Senate motion to exceed and appoint their conferees. But that would amend KSA 60-1507. That's the habeas corpus statute. It would require an action to be filed within 1 year of the decision of the district court denying a prior motion under that section, the opinion of the last appellate court in the state to exercise jurisdiction on that prior motion, or a denial of the petition for review on that motion, whichever one of those three would happen later. The Senate or the House committee also made an amendment to provide that the amendments would not bar actions that are brought within 1 year of the effective date of this act. And as it left the House, it would have been effective on publication in the Register.
And Madam Chair, the Senate amendments and Mr. Chairperson, the Senate did not change the underlying bill, so KSA 60-1507 and the amendments there are the same in both bills. However, on the floor, one amendment changed the effective date to statute book. I believe that was on motion of the chairperson. And then another amendment on the floor added the provisions of Senate Bill 102 as it left the House committee as well with the updates for 2021. So it's a bill that House Judiciary passed, but the House did not. And then Senate Judiciary passed it last session. It deals with civil commitment under the Sexually Violent Predator Act and changing the notification of when a person is going to be released under that act, using the Attorney General and the multidisciplinary team that's already in current law, but just giving them an earlier notice of release. And then also providing for detention and who will pay for that detention and where those folks will be detained while those proceedings are pending. No substantive differences really on SB 102, although the House only has a committee position, not a whole House position. And I believe that motion on the floor was from Vice President Wilborn. So just to give you an idea of where those came from, I think that's it.
Thank you. Committee questions for the revisers on what we've heard so far? I have a quick question for the House on Senate Bill 408 and the removing the definition of what would be subject to the crime of theft of mail. Remove the definition or a sealed article or thing addressed to a person from the definition of mail. What was the thinking on behalf of the House there? Yes.
I'd be happy to let Representative Heiberger answer that question.
I made the motion. It just seemed like it would apply to things that didn't have any value. Like I couldn't identify any circumstances where someone could seal 3 items that were left on somebody's porch that weren't delivered by a delivery service. I ran this by Eric from the chamber, and they didn't have any problem with it. So,
Eric from who, please?
Eric Stafford from the chamber. He did not have any concerns about it.
Thank you. That's helpful to know.
Madam Chair, if I might expand on that a little bit.
Yeah, that one, that's not the Senate position, and I would think that, you know, if you're stealing from someone's doorstep, an item that's addressed to a person and it's taken, it should be a crime.
Well, I think it is a crime. If we'll recall, this amplifies the crime. And so we're creating additional penalties for multiple thefts. The example that was discussed in committee was something like you addressing a Valentine's note and leaving them on your neighbor's doorstep, and a kid coming along and taking them all. Really no value there, but should they then be stuck with a felony for taking those? So that's where that logic came from, something that wasn't necessarily delivered by a delivery service, but just a sealed article addressed to a person.
And to follow up on that, the likelihood of something of value being delivered to 3 separate people on the porch and other than through a delivery service, and then having those three things stolen seems really minimal. I mean, nobody at the committee could find any example where that provision might actually apply to something with any value.
Question for the reviser regarding if under SB 408, as it came out of the Senate, one of the three items could be a sealed article or thing addressed to a person. It doesn't have to be all three for the bill as written to apply. Is that right? One of the three could be a sealed article or thing addressed to a person.
Madam Chair, Jason Thompson, Revisor's Office. So because the definition of mail, as it left the Senate, included sealed article or thing, you're just looking for three items that are mail. So one of them could be a letter, one of them could be something else, one of them could be a sealed article or thing. So the point is it has to be three items that are mail, and then also within 72 hours and part of the same act or transaction, et cetera. So it has to meet all those elements.
Thank you. The Senate had a strong position on this. The Senate was, excuse me, all senators were present, all senators voted aye. And not as strong a position in the House on that. And I think if we're protecting individuals in their home, these are theft at your home by definition. Someone coming up onto your porch and taking something that belongs to you. And I'm concerned that we would be striking a protection for Kansans. Again, this is at their home. That's something we can talk about further, but.
Well, I can tell you from kind of my perspective, I think this bill would have passed the same 117-3 with or without that provision in it. So I don't know that it is this particular piece that important to remain there. So we're certainly open to change it back. Representative Heiberger.
Yeah, I would just point out that what this bill does is takes a crime that would otherwise be a misdemeanor and makes it a felony. Under this bill, if somebody takes three $20 packages off three different porches, that's a felony now for $60 worth of theft. And that was my major concern, that with this provision in it, it takes it down. You can steal things with zero value and have it be a felony. But I'm willing to let it go. So you win.
So committee, do we have a proposal to, since we're talking about 408, we should probably look at 408 first. And there were proposals that, if we're talking about adding to Senate Bill 408.
And Madam Chair, if I might, and this has been sent to the reviser. So I worked with Natalie yesterday evening to put together, to ensure that things were specific to the subject matter context. And a lot of things, of course, were specific to 408 as it relates to crime and punishment. And so what I have handed out and what has been emailed out,
I'm sorry, go ahead.
You're all right.
Question about the chart.
No, you're right. Yeah. So the chart came about as a result of my work with Natalie yesterday evening, putting subject matter topics together. Again, that has been emailed out to the revisers. They can send it out to the list and make that publicly available as well. So just wanted you and everybody else to know where this sheet came from. There's 4 different sheets of kind of proposals that were put together from a House side of things.
So we have a proposal regarding Senate Bill 408.
Correct.
To also include their 4 other bills. And if we could have a bill brief on the other bills, that would be helpful and a good place to start. That's 2516, 2654, and 2517. And we've also already heard a bill brief on 366, which would be included in there as well.
Madam Chair, Chairperson Owens, I can go through these that are in this proposal here. So I believe the House offer would be to have, Senate Bill 408, you guys can talk about which version of 408, but then to add the contents of House Bill 2516. That bill requires an offender who raises error in their criminal history calculation for the first time on appeal to show prejudicial error. It also requires the journal entries used to establish that criminal history to be attached to the criminal history worksheet, and it authorizes the court to correct an illegal sentence while a direct appeal is pending. That bill passed the House 121-0, and some version of that bill did pass out of Senate Judiciary, but I think you made some changes, so Jason can address those when we get done here. And then it would add House Bill 2654, which would provide guidance to determine how offenders under the supervision of 2 or more supervision agencies would have that supervision consolidated into one agency. That bill passed the House 121-0. House Bill 2517 would transfer the responsibility to certify the drug abuse treatment providers that participate in the Certified Drug Abuse Treatment Program. We refer to that usually as Senate Bill 123 treatment. It would transfer that responsibility from the Department of Corrections to the Kansas Sentencing Commission. That passed the House. It also, I believe, was heard and passed out of Senate Judiciary Committee. And then Senate Bill 366, which is a bill that you do have in conference. We briefed that to the burglary bill. So the proposal would be to insert those contents here.
By inserting, does that give us a few shells then if we?
Madam Chair, that would give you one shell. The only bill in that proposal that you have in conference other than the base bill would be Senate Bill 366.
Does it give us any House bills for shells?
No, none of those House bills mentioned there are proposed to be included in this bundle.
And then could we have an update on the Senate hearings on those bills? The ones that got a hearing would be 2516 and 2517.
Madam Chair, so on House Bill, we'll start with the easy one. House Bill 2517, that was the one from the Kansas Sentencing Commission that the Senate committee heard and then passed out near the end. I'm looking for, yeah, it looks like you passed it out on the 17th. The amendment that was made in Senate committee was to change the effective date, presumably to end up here, but then it never came above the line. So that was 2517. 2516, a little more complicated. That is the one where in the Senate committee, the Office of Judicial Administration and the District Judges Association provided testimony and a proposed balloon amendment to remove Section 1 of the bill, essentially to leave the current law that only requires the court and the court services officers to prepare the criminal history worksheet and attach only what they find or only what they use as far as journal entries. So it would remove that requirement that the court services officer go out and find every journal entry for each prior conviction and attach it to the criminal history worksheet. So that was the major change in committee.
Thank you. Any questions for the revisers? Yes, Representative.
And was that change approved by both of the conferees?
It was brought to committee by the conferees to make the amendment that committee did because it was changing and placing burden of proof on court officers rather than on the state. So
The AG and the public defenders agreed on that.
I believe so.
Thank you.
I think it was Office OJA and the district judges, I think, were the proponents that were talking about that.
Madam Chair, if I may?
Yes.
If we're at a point that I'd like to make a proposal as it relates to Senate Bill 408 and these additions. My proposal would be that with 408, we take it back to the Senate version. So we remove the House amendment that we discussed, that we add the contents of 2516, 2654, 2517, which both, all three passed unanimously out of the House, I might add. With all present, not a single dissenting vote on all three of those bills. And then we add the contents of 366 and change that back to publication in the statute book. I believe we changed it to the Kansas Register. We'd like to change that back to the statute book.
Thank you. I do see that, I don't see the vote on 2517, but the others, 121 of the House voted. There were 4 who didn't, but in any event, it was unanimous of those present and voting. We had talked a little bit about 2654 that did not have a hearing in the Senate, and there was some testimony provided from the Kansas Association of Court Services Officers. We talked briefly about that before today, that their concern was if it was the court making the decision, that that would slow things down and encumber the transfer process while weakening local control. What's the House thoughts on that?
I took the time to reread that, look back at the Criminal Justice Reform Commission, because if you recall, this is a Reform Commission bill that was worked by the subcommittee, where we did have representation by the Court Services Association on that committee. It wasn't this particular individual, but they were represented on that committee. The way that we kind of viewed that is a little bit protectionist, not wanting to let go of control, more so than it being an encumbrance, especially since there was representation on that committee. We had proponent testimony from Community Corrections that supported this bill, as well as the Council of State Governments, and it being very well supported with the Criminal Justice Reform Commission.
Did thank you for further looking into that and informing us about what happened in committee and then the follow-up and the reasoning behind how it came out of the House. So appreciate that. We will recess or stand at ease for just a moment while we can confer on this side about the offer. Thank you. and those following along for standing at ease for a few minutes. The Senate has considered the House offer on Senate Bill 408 we have considered taking the Senate position in whole on Senate Bill 408, and then the Senate didn't have a Senate as a whole position on 2516, 2517, or 2654, and the House's offer was to keep the House position on 366, which would be, the effective date would be upon publication in the statute book. If I have that correct?
I believe the House position, we changed it to the Kansas Register. And so we want to take the Senate's position on 366. So Senate position on 408 and 366, and then House position on the 3 House bills.
Right, because the 3 House bills were, 2 of them were passed favorably out of committee and the one didn't get a hearing. And let me confirm, the Senate accepts the House's offer.
Thank you.
With that, before we move on, we do not have our vice chair present because he is chairing a different conference committee. He is chairing the redistricting committee, so he had to leave at 9:30 to do that. So if we want to discuss the next proposal, which would be Senate Bill 366. We've heard the bill brief on Senate Bill 366. If we could get a bill brief on 2515 and Senate Bill 385.
Chairman Owens, do you want me to kind of describe your offer here as you have indicated on this?
Oh, I'm
spreadsheet?
happy
Would
to
that
do
be
that. I
good?
thought we were
Okay.
going to do an explanation of the 2 House bills
Okay,
first from the
yeah,
advisors.
I can do
Go right
that
ahead.
first. Okay, so House Bill 2515 would create a mechanism to seek relief from the Kansas offender registration requirements for drug offenders. And it also allows expungement of those offenses if relief from registration is granted. And then Senate Bill 385 is also some offender registry. It actually includes the contents of both Senate Bill 385 and 368. So it would require registration as a sex offender for violations of internet trading in child pornography or aggravated internet trading in child pornography. And it would also require registration as a sex offender for certain violations of the crime of breach of privacy.
And that was added in the House.
Yes, the House Committee on Corrections bundled Senate Bill 368 and 385 together.
Thank you. Go ahead.
Oh, I was just going to say, so our thought here was that we now have 366, the contents of that in the previous bundle that we've approved. So we use that shell to place basically those 3 offender registry bills in the same bill. I would note that House Bill 2515 passed the House 120 to 1.
Well, we don't have our full committee here, and we do all have to be on the chamber floors at 10. So the House has made its offer, and we will consider that. And with that, then, unless there's anything further for the good of the cause, we will not at this time schedule another conference committee unless you want to suggest one. There is another occurring that involves the Senate me and my colleagues here at 11, so it would have to be something that's
Would 1 o'clock be
post
available?
11. We could keep 1 o'clock open. I'm not sure of Senator Wilborn's schedule, but we'll announce it for 1 o'clock then, and we will get a room, and if we need to change that, then we can announce that as well.
Very good.
And so
Thank you,
with
ma'am.
that then, thank you, and we are adjourned.